Okay, we are live. Hi, this is Anthony Parent of IRSMedic, and thanks for joining me today. Today, we're going to be talking about whether or not your right to renounce your U.S. citizenship is a fundamental right. And the reason why it's in the news is Roger Ver, the Bitcoin Jesus, is being indicted, and he's being extradited back to the U.S. for lying or doing something on his exit tax return. And I could just say, as a tax attorney who does the same work that his firm did, it looks like he did everything right. And it looks like they are just, the U.S. government is making up a case against Roger Ver. Things are a little bit out of control here. And I thought, today would be a fantastic day to give us all a reminder of how we got, what are the reasons why we got here. Too many people forgot about it, but I got a beautiful reminder this morning. Let me just share it with you by my screen share. And then I'm going to be heading over to John Richardson. He's got a fantastic presentation, but this is a little bit of an introduction here. So let me just go with something here. You're not going to believe it, John. Who's retiring? Elise.
Oh my goodness. Look at that.
Look at that. Our girl, Elise Bean. Now, some of you who watch this channel may know that Elise Bean is the claimed author of the Foreign Account Tax Compliance Act. Here she is. Now, interestingly enough, she got 15 things wrong about FATCA. Right, and I have a video another video here. So if you just type in Elise Bean FATCA, you're going to find 15 things. It's 15. Wait, hold on, 15 that this woman got wrong about her own law. But what's interesting is I go to her biography that is on Law 360. Nowhere does it say that Elise Bean is the author of FATCA. I guess she wants to keep that a little silent. And in fact, they don't even mention that she's just a college professor, but rather has been working on the U.S. Senate Permanent Subcommittee on Investigations. But she never mentioned that in her testimony, did she? But so here it is, Elise Bean. So she is the person who is responsible for FATCA. FATCA is one of the primary reasons why Americans renounce their citizenship. It's just a fact. If you live overseas, FATCA makes your life miserable. Now, maybe you're able to find a way around it, but sometimes you're not. I have helped many people reluctantly renounce their citizenship because of Elise Bean, her law, or the law she claimed was hers. Whoever came up with it, we don't know. But I would just say this as well. I mean, Law 360 itself, I kind of wonder if they were paid to write this article. I got to be honest. You know why? Because look how glowing it is. A tribute. If you're a government employee who ruins the lives of many people, you get a tribute in Law 360. Law 360 is owned by some larger company. Relics is actually who owns Law 360, but also Relics also owns a Paris-based anti-money laundering company. So it's all of one big happy home. As long as you're on the right team of big government, you will get beautiful articles written about you. And it's all one big team to sort of pump up this thing, anti-money laundering. They're all stealing from us each and every day. So that's, I thought, would be a great introduction, John, so people kind of remember why we're here. We're not talking about Roger Ver in a vacuum, that this is just some rich guy who just decided to nope out of the U.S. tax code because he just didn't want to pay his taxes. It wasn't that at all. Roger Ver just wanted his freedom. He didn't want to be burdened by FATCA and the cost of being a U.S. person around the globe. So many of the fans, so many of our fans understand. They live it every day. They understand what's going on. So, John, with that introduction, do you think renouncing, if Elise Bean and her government cohorts make your life so miserable, you don't want to be a U.S. person anymore, do you think that right is a fundamental right, or is it just a right that the government may permissively give you? What do you think, John? Good morning to you, by the way.
Well, it really doesn't matter what I think. The position of the U.S. government in 2025 in relation to the Ver case, in 2023 and 22, in relation to a lawsuit brought by the Association of Accidental Americans in France over renunciation issues, is either that which I think is the more likely, that there is no constitutional right to renounce your U.S. citizenship. Or if we put it more kindly, that no court has ever ruled that there is a constitutional right to renounce U.S. citizenship, and therefore it is right, just, and equitable that the U.S. government oppose any claim whatsoever that suggests that there is a constitutional right to renounce citizenship, meaning that although there might not be a constitutional right, that leaves open the possibility of the government, letting people renounce, which they have provided for through the existing statutes. So, bottom line, we're not exactly going through an era of human history where there's a lot of support for the idea that individuals have rights. And I think that this is, I think it's dangerous. I think it needs to be discussed by all over the world. We can start the discussion today, Anthony. And I asked myself, why is this not discussed? And I think the reason is that people on the ground, to use a Keith phrase, do not understand the difference between a constitutional right and a statutory right.
And that's kind of what I wanted to get to. What's the big deal? Why does it matter? Why does it matter, John? Like, hey, look, you can renounce. Who cares if it's a constitutional right or a right created by statute? That is, the government has the right to deny or, well, hold on, maybe that's my answer. If it's a statutory right, then the government's like, hey, look, however, whatever we decide is fine. If it's a constitutional right, then the government might be a little bit limited on how it can do.
Well, that's right. So, to try to keep this as simple as possible, if there were a constitutional right, I'm going to use the word expatriation. That means, in context, usually renunciation. If there's a constitutional right, it means the government can't make any laws that would deny that. Okay, they just can't make any laws that would deny it. Maybe they can make laws that regulate how it's done within certain limits. But the point is this, that if it's a constitutional right, government simply cannot deny somebody the right to renounce their citizenship. Now, to be clear, my reading, of the position of the U.S. government, certainly in the Ver case, they make it very, very clear in their response to Mr. Ver's motion to get rid of the indictment. They make it very, very clear that their view is there is no constitutional right to renounce U.S. citizenship. Or if somebody listening would say, John, that's too harsh, then their view is that no court has ever confirmed there is such a right, and therefore it would just be unbecoming for us to assume there is. However, in the Association of Accidental Americans case a couple years ago, they were, of course, arguing that the renunciation fee was too high, the $2,350. I remember very clear. I was actually listening to the case being argued in the courtroom, and I remember very, very clearly, the government stating its position that there was no constitutional right to expatriation. The actual written decision was a little more nuanced. The judge, in writing the decision, said, well, we don't see that any court has identified a constitutional right to expatriation. We're not saying there isn't, but we haven't identified a court that has, and we don't need to get into that in this particular case because we can decide the case under other grounds. However, no matter how you cut the cake, so to speak, what is very, very clear is that the U.S. government position is that there's not clearly a constitutional right to renounce your citizenship. Okay? And this is, I think, a real problem. A real problem.
Now we're going to get into John's analysis. I know a lot of people are waiting for that. A lot of people are waiting for John's analysis into it. We're going to get to that in a second. But before we do so, first of all, I want to give a shout out to Keith Redmond. Keith, we're missing you. Keith lost his dad last week, so he'll be back on. Our prayers to him. His dad is with his mom right now. So Keith, we love you, bud. Hope to see you out on the show again. And also, I want to give a shout out to Roger Ver. Roger Ver, thank you. And those I did talk to him. I invited him on the show. He declined until after the litigation, which is, if I was his attorney, I would also recommend that too. But we are here to support him, to help his legal team find the basis and also generate the public support for this. You know, this is not the case. What the government did to Roger Ver is so awful. I mean, it's the government that would pass FATCA and say we wanted it. That our government is clearly our enemy, and they're trying to make the biggest example out of Roger Ver, a guy who did everything textbook. He did it the textbook way, but the government wasn't happy with that because he's the wrong kind of person. He's that kind of guy who gives people idea of freedom. We can't have that. So we want to thank Roger Ver for fighting the good fight and not taking this laying down. And by the way, we'll get to comments at the end. So I just want to thank you. But we got a bunch of stuff to get through this fantastic analysis. So with that, I'm going to get up John's analysis that he has right here on his site. There's so much information on his site, Citizenship, solutions.ca. This is where AI should go, by the way. Like, that's where I would go. I would put an AI bot just for John Richardson, and I think, that would really elevate us all. I think, John. So here we go. Here's your article, John. So what's going on here?
Well, I think the thing to do is just sort of summarize this a little bit and the confusion. Because, make no mistake about it, this is complicated. It's not something that I think the average person is going to understand very well on sort of the first pass through. So let me just take you through it as simply as I possibly can, because I think what's important here is for people to get the general message, okay? And they don't have to know everything about this, right? But let's begin with Roger Ver's predicament. Okay, and we have talked about Roger Ver before, and so what's happening is, and this is of interest to me, is this is the second extradition that I'm aware of in relation to an allegation of filing a false 8854. Okay, when people renounce citizenship, you're required to give the government a list of, your assets, etc. And we have the Timken case from a couple of years ago, and now we have Roger Ver case. And where they're at one is that the government's allegations, for a tax evasion are based on improperly completing the Form 8854. In both cases, although there are differences around the edges, the bottom line is the allegation is not accurately reporting assets and therefore not accurately reporting a deemed gain, which would be taxable. Okay, but I think what's important here is that the government is using the extradition treaties, right? Okay, to bring these people back
to justice, right?
Yeah, I mean. It's like George Bush once said, that we either bring justice to our enemies or our enemies to justice. Okay. But I mean, you're right, Anthony, that very clearly both of those people were regarded as enemies I think for reasons that do go beyond the tax issue. But so here we have Mr. Ver, having to deal with these criminal charges and the extradition, and although these things are contextually related, he's probably got an army of lawyers, dealing with different aspects of these things. But I mean, so you're a lawyer. So, if you're defending a tax evasion charge based on the 877A statute, the exit tax rules, I mean, you would agree it would be hugely helpful to you if somehow the 877A exit tax rules were unconstitutional to begin with. I mean, would that be of interest to you if you were Roger's lawyer?
That's a great, you know what I mean? Essentially, it's giving you kind of a free swipe there to say, hey, look, whatever you're doing here, you don't really have the basis. And thank you for stating the issue that was this is not a case of someone not reporting their income. That's not what it's about. This is, hey, give us a value of your assets because you're going to expatriate. We're going to miss out on that. We're the U.S. government. We're going to miss out if you're no longer, if we're not able to tax your stuff. So you got to list the value of all your stuff, and we may tax you on the value of your stuff. Well, Roger Ver had the problem of owning a lot of Bitcoin in early 2014 when Mt. Gox, and let me repeat this again, Magic the Gathering online exchange, the largest exchange that was originally for people trading cards. Trading cards, that's what it was for. That just crashed. Just to understand how amateurish Bitcoin was looked at the time in 2014, everyone, it was a joke. Bitcoin was a joke in 2014. So Roger Ver is trying to put down like, all right, well, it's worth something. But if I sell it all, I'm going to throw off the market. I might tank it to nothing. Roger Ver may have been able to destroy Bitcoin at the time if he sold it. So he's trying to put some valuation down of his Bitcoin, which is a joke. And now the U.S. government wants you to go to, oh, you should have a time machine. You should have a time machine, Roger Ver, to know that actually it was going to go up. Yeah. So that's really the essence of the case there. That's really what this is about. And someone.
So the case, right, to be clear, right, I mean, you have to be somewhat of a technician here. I mean, that's the context. But the specific case is that, the exit tax rules are Internal Revenue Code 877A, and they require, they mandate a deemed sale of these assets. And what they're saying, rightly or wrongly, okay, is that he simply did not accurately report the deemed gain. Okay, so that's where we are with that now. So if you're Roger's lawyer, right? If somebody walked in and said, that client you got, Roger Ver, they essentially the tax evasion charges are based on this 877A statute. Well, you know what? We think that statute's unconstitutional to begin with, right? And if the statute 877A is unconstitutional, well, then it's pretty clear that trying to charge somebody on a tax evasion crime based on 877A is like a nothing burger, right? You just can't do it, okay? So that's the context of what we're really exploring today, right? Is the constitutionality, or at least beginning the discussion of the constitutionality of 877A, right? The deemed sale rule. Now, his lawyers, I think made 2 points. The first that we're not going to talk about today is that, and this was really the Moore issue all over again, right? That because 877A is a deemed sale without a realization event, that therefore, the statute is unconstitutional in that sense. Well, we'll see where that goes. We'll see where that goes. I mean, I have some comments on that. If we have time later, maybe we'll talk about that. But the other thing they're arguing is that 877A, leaving aside the deemed realization thing, right? That the 8 as a separate legal argument burdens unjustifiably a constitutional right, okay, or a fundamental right in the language of the case to renounce U.S. citizenship, right? So the idea is that if it burdens a fundamental right, that doesn't necessarily make it unconstitutional, but what it does do is it shifts the burden to the government to justify that, you absolutely have to have this statute, blah, blah, blah. So what we're talking about today is the question of, is expatriation, renunciation, is it in fact really a constitutional right or a fundamental right? A principle of ordered liberty, these sorts of things, right? Or not. And the government's position, of course, is that no, there is no right to renunciation at all, right? Now, that tees us up for what the problem is. Now, before we talk about a couple of other things, one of the things that is very confusing about this is that the Supreme Court of the United States and it's hard to reconcile all these things, right? But the law is very clear that the government cannot uh, strip you of your citizenship without your consent. The government cannot strip you of your citizenship, right? And we have that from the seminal cases, the Ephorium case.
But
They
John,
can
why
strip you
can't
of
the
your
government strip
citizenship.
you of your citizenship?
Well, move down a little bit, and I explain it in terms of the 14th Amendment of the
Okay.
Constitution. Just move down a little bit now.
All right.
Okay, yeah, here we are, 14th Amendment. Now, if we look at that here, you'll know now this is a constitutional provision. And again, I think the average person on the street doesn't understand the difference between a constitutional right and just a right created by statute. Constitutional right means the government can't touch it, right? Now, what the 14th Amendment says, among other things, right? All right, now notice it says all persons born or naturalized in the United States. Let's ignore the word subject to the jurisdiction, okay, in this discussion. Says are citizens of the United States, right? So we read that all persons born or naturalized are citizens of the United States. That's what the Constitution says. So where does the government get off saying, well, we're going to start stripping you of your citizenship? Nobody. We've got the 14th Amendment here that says you can't do that because it says all persons born or naturalized are citizens of the United States. You got it?
Well, John, and if I could just sort of refresh here, because this is where you're just sort of like, you're thinking of this government like, man, they just really have no shame here whatsoever about their arguments. But let's just say this: citizenship is a constitutional right, and the reason why I know that is that I'm looking at the Constitution. The 14th Amendment is the U.S. Constitution. So, well, there it is. It says it right there. And then if you don't believe the 14th Amendment, then I would just say this. What document out there? What document out there, John, if it's not the 14th Amendment, makes you a U.S. citizen? What document? What document? How do we become U.S. citizens? What was there a document then?
Well,
Is there
well,
a written
there's a
constitution?
statute. I mean, they're different. It depends on who you are, right? As always, right? Now, notice that this says all persons born or naturalized, right? So, you would, if you're asking how you would prove that, you'd say, well, by a birth certificate. Notice the Trump executive order, right, though, is saying to the government agencies, do not issue birth certificates to certain kinds of people, right? So, although somebody born in the United States, the majority view of this is that if you're born in the United States, you're going to be a U.S. citizen. That the subject of the jurisdiction part cannot be used.
But John, this is my point here: is that the U.S. Constitution is the highest law in the land, and that's the document.
Yeah, absolutely.
That's the founding document of our country, and that's what makes you a citizen. So this is a bizarre argument. This is a bizarre argument.
Well, let's wait till we get to what their argument actually
right.
is. Now, going narrowly here, right? So where we are, and this is the Ephorium case. And before we leave it, let's go back up there for 1 second before we leave it. There are a couple things that I think are of interest here. So in the 6-7 Ephorium case, and this was only a 5-4 decision, by the way, okay, but the court rules that the government, that the citizenship belongs to the individual, and the government cannot do things that result in the forcible, stealing of citizenship. And I would argue that these crazy rules applying to Americans abroad are forcing them to renounce. And, I think that the complexity of the U.S. tax code may, really be creating the forced renunciations of citizenship and therefore violate the 14th Amendment. But that said, there's another point that I want to make here. Notice that the constitutional provision is restricted to people's born or naturalized in the United States. So, we have these U.S. citizens living who were born outside the United States, the U.S. citizen parents. I think that it's very, very likely that the U.S. government could strip all those people of their citizenship. Okay, in other words, this is narrow stuff, right? This is narrow. Now, I know there are people who disagree with me on that, and it's not like there's only so much I can do for these discussions, Anthony. But it's very, very clear, what this says. It refers to
Yeah.
people who are naturalized, right? Now, again, here's where we are. So the court has ruled that, if you can prove that you're born or naturalized, you have a right to retain your citizenship. The government cannot strip you of it. But notice that what we're into with the accidental American situation or with the Roger Ver situation is not an argument about whether somebody is a citizen, but whether they have a constitutional right to renounce. Right? Now notice that is not covered by this part of the 14th Amendment at all. Right? So we have the 14th Amendment is the constitutional basis underpinning, if you will, for the claim that I'm a U.S. citizen, there's nothing you can do about it. And by the way, why might this matter? It might matter. I mean, there's discussion about sending, people to Guantanamo and things like this, actually, no, that was immigrants, or sending people to El Salvador, this type of stuff. I mean, we're into a whole new world of what citizenship means. But now let's consider this from the point of view of, does somebody have a right to renounce it? Now, you would initially think, and I think I initially thought, and a part of me thinks today, that, if you take the reasoning in a forum that the citizenship belongs to the individual, right? If it belongs to the individual, then, is that not a strong enough underpinning to say that they also have a constitutional right to get rid of it? Well, I think that that's likely to be litigated at some point. But as you might expect, governments around the world are generally hostile to human rights. And the U.S. government is, of course, no exception to that.
So I'm one of the most hostile.
Yes.
No. Yeah.
So let's look at, so if you're a lawyer, how do you make the argument that, there is a constitutional right to renounce? And so far, the answers have been based going down on a Fifth Amendment type of argument. You can go on down a little further here.
Okay. And I just as you were talking, John, you said something that just sort of cracks me up. It's so absurd. But let's just say this, many times, hey, in a 5-4 decision, the Supreme Court ruled that was a fundamental right.
Well, they ruled that
whatever it is, but I'm just saying the point is that wow, a 5-4 decision, this court can decide what's fundamental and not.
Well,
that seems really weird.
It's hardly unanimous. It's hardly unanimous, and that's why, just to get one of my personal views on this thing, the single most important issue in presidential elections is who are the judges they can appoint, right? I mean, that's how they keep their legacy.
Exactly. Yeah. Right. So okay. So yeah.
Here we go to the Fifth Amendment now, right?
Okay.
And the argument is this: that I've tried to highlight the part of it. So the government people cannot be deprived of life, liberty, or property without due process of law. Okay, now this is not something that I have any particular expertise in, but I mean I can read what the arguments are, and they are the arguments in favor of constitutional right to renounce appear not to be based on the Aformium decision, or not exclusively based on the Aformium decision, but are based on the Fifth Amendment that, you have, that renunciation is a liberty, okay, that cannot be deprived without due process. And because, expatriation is a fundamental right, et cetera, that therefore it cannot be denied. Now, as far as I'm aware, no court has ruled on that definitively one way or the other, but the government lawyers are, responding to this by saying, look, yeah, I mean, we accept that, you have a right to remain a U.S. citizen, but that's because of, this section of the 14th Amendment. That section of the 14th Amendment should not be construed to talk about whether you have a right to renounce your citizenship. Okay, so there the discussion seems to be hovering around the Fifth Amendment arguments, and there's been no answer to that particularly. So that is where we are. Okay, now what that means is that, at present. Now, there may very well be, a court may very well find that there is, a constitutional right to renounce. They could possibly do that by reading that into the Ephorium decision, right? On the principle that, well, if you have the right to keep it, you have the right to get rid of it. Okay, something like that, I think is an argument that occurs to me should be made. Or, this whole issue of due process and that sort of thing. So that's where we are. But when we look at the statutes moving down, so so the government would say, well, in any case, you have a right to renounce, and we've granted you that right in 349A of the Immigration and Nationality Act, right? So move on down.
Yeah, and I just want to, and I just before we go a little further, I just want to chime in here with some things that people might not pick up on. So that liberty part there, right? That liberty part is just sort of breezed over, but it says deprived of life, liberty, or property without due process of law. We don't have a lot of text here, and I think there's people have a misapprehension of what that means. And so let's just go back and do a little bit of history. There was really no problem with the Articles of Confederation. There really wasn't anyone. But really, Washington and his Federalist powers needed to create crisis because the problems with the Articles of Confederation is it didn't allow for the graft. There wasn't this massive taxing authority that you can go and become rich off of. So that was really the problem with the Articles of Confederation. It allowed for a lot of liberty. So George Washington, all the Federalists, they got together and like, okay, we got to create a crisis so that we're going to propose a solution called the U.S. Constitution. Now, Madison did not want a Bill of Rights. And you might think, what a jerk. But actually, he had a really, really good point. And his point was like, look, if the federal government does not have this articulated power, they can't do it. We don't need a Bill of Rights. If the government doesn't have a power, we don't need a Bill of Rights to stop them. So Madison was all against it. However, the anti-federalists were like, well, we don't trust you guys because, well, we don't trust you because you seem to be lying about the Articles of Confederation. And so the anti-federalists said, look, we're going to need a Bill of Rights because you guys are going to do all these things we don't like. And then Madison said, he said, look, the problem with that, guys, is the curse of negative implication. That if it's not particularly banned, then the courts can say, oh, no, it only applies to that, it only applies to that. And so, in fact, when everyone looks at the Bill of Rights, they tend to look at it all wrong. They tend to look at it, it's like, what does that text say? It's like, doesn't matter what the text say. What's the right it's trying to protect? The whole debate of the Second Amendment is ridiculous. There is no debate because we're supposed to read it expansively, not the narrowest little way possible, which is what they do all the time. So when we're reading this text, we need to say, no. It's like, no, that's right there. No, life, liberty, or property without due process of law. That's huge. Those terms are huge and actually define it. But now the government always does a bait and switch, though, right? You kind of see how they did that. They did a bait and switch. And then also the other problem that I have is the 14th Amendment, because the U.S. Constitution gets the United States government gets all of its power from the states. The states define what powers the U.S. government can have structurally. But then the 14th Amendment comes in there, and now it's the federal government defining state rights. And that's kind of the whole disaster. That's a separate issue. But that's why it's like we got to be careful of what we're looking at, because the 14th Amendment wasn't really a good thing, because what it did is it made the U.S. government a super state that gets to define everything. And that's the problem with it. And that's what we're seeing with. So, all right. So we'll back to you, John.
Well, I mean, you make an excellent point, Anthony. And this is actually the second time in the last 2 or 3 days I've listened to, sort of a lecture, pretty much the same thing. And if I can just, simplify that a little bit, okay? So what we're really looking at is a question of whether there's a presumption of individual rights or there is no presumption of individual rights. So, the argument that you're making about, historically or, at first instance, any power not given to the states, to the federal government, was retained, by the states or the individual, then, you see this. I think it's a lot easier to argue this in terms of a presumption of all of these, rights that may have existed at the time, et cetera. Um, what's clearly happened now, though, is that we're in an era of a presumption of no rights,
No, right.
and that you really have to work hard to to carve this stuff out, and that's, I think, part of the problem. And
Well, and actually, and if I could just chime in with one more problem, the problem is law school education. That is not when you take constitutional law in law school, it's not constitutional law. It's Supreme Court, whatever you want to call it. It's a Supreme Court stroke off. It is not about the Constitution, because this is what we're actually taught this in law school. It's all the same curriculum that comes from Harvard and Yale. It's all the same curriculum. All taught the same nonsense. That there's actually a debate. We're actually told that there's a debate between natural rights and positivism. That, oh, well, actually, all the rights come from the government, and that's that they actually present that as a legitimate side. When you look at the history, there is no friggin' way. There is no friggin' way. That is the way it works. It is individual rights granted small federal right. People give powers to the states, and states give limited powers to the federal government. That's what it is. There is no debate, but yet in law schools all across the country, I'm sure it's happening right now today. Someone is taught that, oh, you know what? Your rights come from the government. Whatever they decide you deserve is what you get. So that's one of the biggest problems we have, is that law schools are in on it and miseducating people. But anyways,
well, I think that there's an element to that, but I think that personally the biggest problem is the legal profession. Uh, I
you
mean,
just agreed with me.
I've long been of the view that what happened in Nazi Germany was very much facilitated by the legal profession, right? Their unwillingness, to stand up to this type of thing. I mean, I think that you need to work on the assumption that all the governments, by their very nature, are going to tend towards, being tyrannical. Okay, that's just what the nature of
Yeah.
government is.
Yeah.
Whether it's the United States or Canada or any other, whatever. Look what's happening in Britain now. All this surveillance stuff, etc. So, I think that obviously this is an old-fashioned view of what a lawyer should be, but
Yeah. Yeah.
I think that the legal profession, should see itself as having a responsibility, to stand up for this. But in any case, we digress.
Yeah.
So, where we are with this is really a question at the moment of unresolved, right? I mean, does an American have the constitutional right to renounce citizenship or not? Now, even without that, at present, there is a statutory right. We find that in Section 349A of the Immigration Nationality Act, etc. But as I speak to you today, I'm reminded 7 or 8 years ago, I was at a conference in Europe, and I found myself seated beside somebody at lunch who's I won't mention, but who's a very well known, person in the world of taxation and that. And we were talking about renunciation, and he said to me, "Well, right now people can renounce. I wouldn't hold my breath, on that down the road, right?" And although I don't think that the statutory right of renunciation is in any danger at the moment, I do believe that whether it's a constitutional right or not is unclear. I would also point out, and I've written a number of blog posts on this recently, that even if you have a statute, there's wide latitude in how to interpret that. I mean, to give you an example, um, as you know, for years I have helped people get certificates of loss of nationality based not only on renunciations, but based on other acts, okay, naturalized a citizen of another country, certain kinds of government employment, all of these things. And about 2 years, and I was doing this like clockwork, some were easier, some were harder, but I was getting these things, with close to 100% accuracy. And about 2 years ago, the government stopped responding to these things, right? I mean, you help people with a renunciation, they get their CLN within a month or two. But for these other things, they just stopped responding. Okay. They took their money. They just wouldn't respond. They wouldn't issue a CLN. They wouldn't do anything. And then what happened was that a few of them were contacted and said, we want to re-interview you again, etc. Now, the law's not changed. The statute is still there. The law hasn't changed. But clearly what has happened is that the way the bureaucrats in D.C. are interpreting intention, voluntariness, burden of proof, that really has changed, right? So in other words, even if the statute, remains on the books, believe me, there's plenty of latitude to interpret this stuff in a way that, that the requirements of the statute have not been met. All right. And I do predict that for the first time, we are going to see people trying to renounce where they're going to make the decision that there really isn't voluntariness or intention or something. I mean, I don't expect a lot of this, but if you look at the new DS 4079, anybody who's who knows a lot about this, and has been in this swamp for a long time, will see where the changes are. But in any case, that's where we are with this.
And I think it's just, I highlighted that because in the 2002 accidental case, the courts did not rule out the possibility that the right to relinquish was the right to relinquish was a constitutional right. So all right, so we're going to move on because then you have another part here.
Well, this is the created by statute. Now, so there's the text of the statute.
Okay,
right?
So now we're going. So it's like, okay, so the government at least acknowledges that this exists, right?
Well, that's been around forever. Yeah. That's what I was just talking about. So you look at the loss of nationality. Let's look at what it says here. At present, here's your statute: loss of nationality by native-born or naturalized citizens. Voluntary at burden of proof. Person who's a national of the United States, whether by birth or naturalization, shall this is mandatory, voluntary performing any of the following acts with the intention of relinquishing United States nationality, right? So you look at that. Notice that includes naturalization of foreign state. It's not that simple, though. If you get down to 5, it's taking the oath of renunciation. Et cetera, et cetera. But, the problem really comes down to, if you look at section B, the burden of proof.
Further down. Oh, B right here. Okay.
Yeah, there you go. Whenever it's put into issue, blah, 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 the burden of proof lies on the person, making the claim of loss of nationality. It's a preponderance of evidence. And what I'm seeing is that, with the exception of renunciations, that it's getting very, very difficult to meet that standard. And that, by the way, is just an administrative decision. It's like the Trump EO, saying, well, we're just not going to recognize this stuff, et cetera. So, we're in a new world as far as backdated relinquishments. However, there's another statute that's still on the books. If you can keep going down there.
Yeah, well, just to get, it's you by a preponderance of the evidence. You have to prove you renounce your citizenship. Okay, well, that's just sort of standard of proof.
Well, but what is it you're proving by a preponderance of the evidence?
Right. Yeah,
so B is just where the burden of proof lies.
The burden, because and I think the issue is this loosey goosey of definition. It's like, hey, you have the burden of proof of what?
Voluntariness and intention. Okay. Yeah. It's like the criminal law mens rea actus reus thing, right? They have to coincide.
Knowing and voluntarily made. Your plea of guilty must be knowingly and voluntarily made.
Well, at the time of the act, right? So, these really should be seen, and I do see these as more on how to interpret criminal statutes, right? Where you have to have both, the mens rea and the actus reus simultaneously.
Mm-hmm. Yep. All right.
A lot of people mess these up, but here, pause here.
Right here.
Now here's a statute that's often referred to. It's interesting, and I believe this is still on the books. The 1868 right of expatriation. Now, so we're having an argument with, is this a fundamental right, a principle of ordered liberty? Has been part of the fabric of the nation? And this is saying, well, whereas the right of expatriation is a natural inherent right of all people, indispensable to the enjoyment, blah, blah, blah. Okay. Now, Uh, what's interesting about this is that if you read the context of that, really had to do with people coming from Europe or other parts of the world and wanting to be American citizens, and other countries not letting them go. Right. So, no, really, really. Okay. So what was happening was that the U.S. government was sort of, putting a statute there to protect the right of those people, at least under U.S. law, to renounce their previous citizenship and become Americans. But as a number of historians have pointed out, I mean, if you want to move down a little further, I think I referred to.
I don't want to. I don't want to move down yet, John, because that right there is the government saying the right of expatriation is a fundamental right. When you see natural and inherent, that is a synonym for fundamental right. So when the government
Who it's
wants people
applying
to come to the U.S., it will be a fundamental right. Hey, I think they're stuck with this. Guys, you've already written it down. You've already said it's a fundamental right. You've
Well,
already said it.
a fundamental right for who, though? Right? Notice it says national.
Of all people.
Well, but hold on. Then they say the government has freely received immigrants from all nations and invested them with the rights of citizenship. The argument is that this applies to people coming to the United States, with leaving open the question of whether it applies to American citizens.
I don't see that. I think that's what they want. That's what they want in there. But that's the recognition of this principle. What principle? That expatriation is a natural right. So it doesn't say, oh, we're only going to limit it to people coming in. It's like, I understand that that's what they're doing. But this is the government saying it very clearly that expatriation is a natural, inherent right of all people.
Even Americans?
Indispensable.
Even Americans?
Even Americans. This is it right here.
You mean to say that we actually
got a lot of fucking balls.
We actually have a statute from the U.S. government giving all Americans a right?
It says it right here. It says it right here. Why do we need it? Why is this a dispute? The federal government already said it is.
Okay.
This is incredible. They're saying it's a fundamental right. Well, we don't know about that one because we don't like it. I mean, that's.
Well, I will tell you something interesting. You may see this as trivia or not, but if in the Foreign Affairs Manual, issued, obviously by the State Department, where they're talking about, people coming in wanting to expatriate, they do make reference to this. Okay, they actually do make reference to this in the Foreign Affairs Manual. So maybe. There's a great.
Wait. Therefore, any declaration, instruction, opinion, order, or decision of any officer of the United States which denies, restricts, impairs, or questions the right of expatriation is declared inconsistent with the fundamental principles of the Republic. I'm going to lose it. I am honestly going to lose it. This is them saying. I wouldn't write. I mean, they wrote exactly that expatriation is a fundamental right that you can't screw with. And our government is just like, oh.
Anthony, you're getting excited.
I am getting excited. I mean, here it is.
This is great. Like,
we won. We got the law passed. The law says it. We got the law passed that says expatriation is a fundamental right that you can't mess with. And look at this. Everything they're freaking doing. Everything. They're in such violation of this. And the question I have is, what should be the penalty when someone breaks and ruins someone's constitutional rights? You know what I think the penalty? We don't talk about this. The penalty should be execution. That's what the penalty should be. This is screwing with people. Flying right in the face of the exact text. Unbelievable. No, it is believable. Sorry.
Of course it's believable.
It's this government. This is how depraved they are, folks. This is how depraved they are. There's the U.S. Code clearly states the right of expatriation is a fundamental right. And this government's going to go right past that.
Well, now let's pause for a minute and let's put our lawyers' hats on, okay? So let's say that it is a fundamental right. Let's agree with this, okay? It's a fundamental right. So the question is, what would that mean in the context of a constitutional argument? I think if it's a fundamental right, um, probably they cannot outright prohibit it. Okay. Uh, but if they can, or anything they can do is going to be subject to a very high standard of justification, this strict scrutiny thing, right? So it certainly limits it. There's no question about that. And, clearly, Anthony, this statute would and should be front and center in any legal argument, right? Because so much of this, as you point out, a few minutes ago, so much of these discussions has to do with assumptions, right? And you were identifying, the issue of, well, do we have a presumption of no rights or do we have a presumption of rights? Okay. And to some extent, if you win the argument on where the presumption lies, you're going to win the whole thing. So here, you use this to argue a presumption in favor of expatriation being a fundamental right, et cetera. So that's why it's valuable. Now, what would that mean? It would mean that the government would have to have, well, it would have to have, but it would have to be able to prove, okay, on some kind of evidentiary standard, probably strict scrutiny, that they really have to behave in this way, right? So in this context, I mean, do we really have to have an exit tax? Does it burden it, et cetera, et cetera? But I mean, there's where you're, I presume, you start digging around and formulating your argument. There's a great book on this. Professor Lucy Salyer, a history professor, wrote a book called Under the Starry Flag. All right, if you move down a little bit, I think I've got this. Yeah. So move down a little more, because I think I've quoted, or maybe I didn't. Anyway, I mean, she actually ends, I wrote a separate post on this issue, but I mean, she actually ends her chapter discussing this 1868 right of expatriation with the question, whether this was actually intended to apply to Americans as opposed to non-Americans. So believe me, there's plenty of analysis out there that is of the view that 1868 statute was never intended to apply to Americans at all.
And that is an utterly sick. I mean, I get it because, well, hey, look, this was about people coming to the U.S. and we're one way. I understand how people want to be dishonest, but when you say things like this, whereas the right of expatriation is a natural inherent right of all people. I don't see except Americans. I don't see that. It's
well,
people.
You look down a little further, and the justification is this has freely received immigrants from all nations. I mean that's where it is. Look, obviously, I agree with you, Anthony.
Yeah. Right.
The problem is the world doesn't operate based on what you think or what I think. It's
there's a lot of misinformation.
There's a lot of stuff that has right. So I mean, wrapping this up, and then opening this up for comments, I'd be very interested.
Yeah, let's get to some comments here.
I think where we are with this. I think where we are is that I think there's a real question at the moment, as to whether the courts are going to consider renunciation, expatriation to be a fundamental right. I mean, here's what they say here. Here's what they say. Look, this is right out of their damn factum. Contrary to Ver's argument, the Supreme Court has not recognized the right to abandon one's citizenship constitutes a constitutional right. Notice they actually cite the Accidental Americans case from a few years ago as one of the cases they cite. And this illustrates the problem, right, of raising this, the danger of raising this type of stuff, okay? Then we move down a little bit. I also included excerpts from the Accidental American decision. Move down a little bit. Keep going. Keep going.
Here's the court would need to engage in a lengthy historical analysis, which Ver does not address. So there's a pro tip: address the historical part, guys.
Yeah, absolutely.
Make sure you look at the context of what was actually. That's what you need to focus on. By the way, and this is what I would say is most people don't understand how appellate law actually works, and I found this out as a young attorney. My client was very happy to find this out. You don't win cases on the law. You don't. The law is backfilled to reach the conclusion the court wants based on the facts. You win your cases on your facts. The law is going to be whatever they want it to be, but the facts are what's going to determine the outcome. And so that's what you always want to start off. Facts will win. The law doesn't matter, because if they don't like your facts, they're not going to listen to you. But if they like your facts, all of a sudden you find justice. So that is one of the biggest keys. And the factual background to this entire thing is incredibly helpful, something that the whole world can understand. So that is what I would say, is I would want to just focus a little bit more on the historical, aspect. What was really agreed to. Okay, go. So here's more, John. Anyway, back.
Well, yeah, continuing on down. Let's look at the excerpt from the actual Americans' decision. If we keep going down, I think I've got.
Yeah, well, and it's just like, in some, there is no fundamental right to expatriate deeply rooted in the nation's history and tradition. Well, there is that law. There is that law that says it is.
Well,
there's a congressional act that says it is. But hey, look, we have an attorney who says it's not, right?
Well, that's right. That's right. But continuing.
Okay, here we go.
That's the factum. That's the government factum, right? But here's the extra from the court decision, the Action on Americans case, moving down a little more.
Yeah.
Let's see. Did I highlight this? I probably should have highlighted it. Yeah, but there you go. The Supreme Court has not recognized the right to abandon one is a constitutional right. Okay. The D.C. has not addressed the question either. At oral argument, and I was actually in the courtroom watching this going on that day. At oral argument, plaintiff's counsel, that was Mark Zell, by the way, acknowledged that this would be the first to recognize such a but noted in their brief that there are cases where there's reference to statutory right without referencing the due process clause, et cetera, et cetera. And then with the judge, what she does then, that's worth reading. You put up the link to the post if you like, whatever. Okay. But then you get down and she finally just ends with, look, we don't need to decide this in any case. And we're not going to get into this, to make the decision.
Yeah. Okay.
All right.
Let's get to some questions here then. All right. Thank you everyone for hanging in there. And now we'll get to the questions. All right. Let's see what we got. All right. Here we go. FACA. Hopefully, yeah. I think so. We got some big problems with FACA. Yeah. Thanks, Merce. Thanks for the prayers for Keith. Okay. What's the difference between a statutory right of privilege if it can be taken away when the government wants? Right.
Well, the point is that the government, in theory, cannot take away no difference between a statutory right and a privilege. That's the point, right? No difference at all. A statute can be changed, and that's the problem. From the point of view of these government lawyers, they would have no problem arguing that the government could simply repeal 349A of the Immigration Nationality Act, removing the statutory right to renounce. They would have no problem with that argument at all. That's why, if you want to renounce, I would get on with this. Okay. We're not dealing at the moment, and will not be for a number of years, I think, in any kind of legal and political environment where there's anybody's going to be reasonable. Okay. So
yeah, whatever's going on. Yeah. All right. McNello disagrees with me. Yeah. All right. As a constitutional originalist, which.
Yeah, no, that then he would agree with the fact of the government lawyers. Sure.
Well, you're not an originalist, then you're a positivist. You're saying that the
master. Well, he's just saying, Anthony, there's no constitutional right to renounce. Now, on that, okay, I think we could add that, at common law, right? At common law, there was a doctrine of perpetual allegiance. And by the way, the War of 18. Was it the War of 1812? Yeah, I think the War of 1812 was largely fought over this issue, right? With British, simply
impressing, British impressment,
picking up these U.S. sailors, and these are our people, and throwing them on the boat, etc. So that was.
Well, it seems like they had a right to renounce their British citizenship.
No, they did not. That was the point, right? That was precisely the problem that, the British, and by the way, here we can see this
But what country said that they didn't?
Sorry?
What country said, Britain, you don't have the right to impress these American citizens?
Oh, you mean the one where you're sitting in right now?
Yeah, exactly. It was, well, so the United States of America is going to, so they're going to take the British argument in 1812
Well, exactly.
to find that
Exactly.
there's no constitutional right to renounce. I mean, that's how far we're going to go.
That's right.
You're actually going to say take the British side.
Yeah, that's exactly right, Anthony. I mean, you know, that's where things were. I mean, there's a common law of perpetual allegiance to the sovereign. Okay.
Well, and here's a good question from software. Is
There
voting a
is no
stat?
constitutional right in the United States to vote. There is no constitutional right, to be clear. Look, Americans have fewer rights than citizens of most other countries. They just don't think that's true. But there's no constitutional right to vote. There are parts of the Constitution that prohibit discrimination in when you allow people to vote. But I will say it again, there's no constitutional.
Oh.
And by the way,
So whatever the
it's a
law
very
is, it
interesting
has to be
point.
equally applied, whatever it is.
Yeah,
So as long
yeah,
as it's equally applied,
that's right. As long as it's an equal prohibition, right?
equal prohibitions.
Yeah,
Oh my God!
that's
Well, I
no
learned
problem.
something. That's shocking. That's
But look,
shocking. Well, hey, look, in the government's defense, then hey, look, you don't have a right to vote. What gives you the right to expatriate, right? Hey.
well, I mean, I think they're different things. But focusing on the part of this that if you're a felon, now this is very, very interesting to me. Many years ago, I don't know if I ever told you this. When I was, well, obviously many years. This was when I was in law school, well back in the last century. I actually taught 2 days a week in a federal penitentiary.
Oh boy,
Yeah.
you didn't tell me that. This sounds like an entire treatment for a television show. When John
I don't
Richardson.
know about that particularly, but I mean, it was just, I mean, I was interested, like you, I was very interested in criminal law. And it was just, they had a community college program where these people could get a, some kind of a diploma. And, actually it was law. Law was a required course. So I taught the law course. But, what was interesting to me was that, so you go into this thing and, the security was, extreme. But these were just people who they were, like you and me mostly. I mean, in the sense that they weren't bad people. They were just in the wrong place at the wrong time, and they didn't have the reading skills. And I mean, the whole, issue of who's been incarcerated, is a terrible problem generally. But let's look at it this way, right? It's interesting that I think most states, certainly Massachusetts, that was the last one I looked at, they do prohibit prisoners from voting. How can this be just or reasonable, right? Because, I mean, don't people who are incarcerated, shouldn't they have the right to vote for the very laws that they're being jailed under? I mean, this is insanity.
Right, I know. Right? You gotta love it. Well, I see you're a felon. Oh, okay, but right, and I mean, when we have so many laws, we're all breaking 3 federal felonies a day. We don't even know it, right? We have so many laws, we don't even know what we're breaking. Next question.
Seriously, we ought to do a separate show on this whole issue of the right to vote.
I know, right? Wow, I know that is crazy.
Let's see what else we got here.
All right, we got musical Salo. How can the government tax you based solely on the fact that you continue to retain your right or citizenship? How can a right be that sole basis for taxation? I've never heard a good reason for this. All right, music. I want to handle this one because I didn't mention it yet, and it does bear to be mentioned because so many of these horrible things, that our country became, we have one person to thank. Unfortunately, he is often regarded as a hero, and that person is Abraham Lincoln. Abraham Lincoln was by far the most destructive president we've ever seen. If you look at proportion of the industry, the country destroyed, how many men were destroyed, what he did. And then his lasting legacy was to create this federal government superstate that was more powerful than everything else. And so where the government creates these rights, and it's really when we actually have to look to Lincoln to answer this question, because the Revenue Act of 1862 was the first income tax passed in this country. No 16th Amendment, because Abe Lincoln doesn't need the law. He doesn't need that. He just went ahead and did it. And Abe Lincoln imposed it on citizenship-based taxation. He was the one who did it. And the reason why is because might makes right. Unfortunately, that's what it is. Hey, look, the Union won the Civil War. It was settled. The government gets to decide everything. And if you want to leave, they can murder you. They can murder you if you don't like to leave it. So I see a lot of analogs between Abraham Lincoln not letting the South leave the Constitution, even though he agreed there was a right at one point, but then he's like, oh, no, I'm going to change my mind on that one. So I see an incredible, that is, unfortunately, Abraham Lincoln is the reason why America is so terrible now. He is the number one reason why. And his, the 14th Amendment radically changed it. And our government radically changed after the Civil War, not for the better. That's where we can find all of these things from Abe Lincoln. So I'm not sure if John agrees with me on that one, but
I don't know enough about the history.
There you go.
I certainly agree that.
Yeah. And then it's kind of the same thing. It's like, how can one be taxed solely based on the fact, well, good. Look, here's the thing. The federal government isn't interested in logic and reason. It's interested in power. Power. That's what it wants, and it will lie to you, and it will do anything to get that power. That's what its concern is, and it has been. We can thank Abraham Lincoln. That is where we can go to. We don't need to go much further, right? And then unfortunately, we have to go to all the people who think that Abraham Lincoln's a good guy. Oh, he preserved the Constitution. All right, Johnny Thunders. Here we go. Johnny, great to see you. Nothing is being mentioned in the Constitution about abortion or gay marriage yet. Landmark decisions have been issued. Yeah, and you don't need, and the thing is that you don't need things to be articulated in a Bill of Rights. And that was the whole problem. And the curse of negative implication still curses us to this day, because people will only look, I don't see this little right in the Bill of Rights. Nope, the government can do it. That's not at all. That's not at all the way Madison designed it. Constitution was a bad idea, but it would have been a lot better if we actually listened to Madison.
Yeah, I mean, what Johnny Thunder is saying is, of course, absolutely true. And, probably the most prominent example of this would have been the Roe versus Wade decision. Was that Justice Powell who wrote that decision? Well, whoever it was. You may remember when President Reagan tried to appoint Judge Bork to the Supreme Court. And, Judge Bork was made the argument that Roe versus Wade was the wrong decision, and it was largely tied into there's absolutely nothing in the Constitution, that would give this right of privacy upon which Roe versus Wade was based. But 100% right, and what this means, of course, is that what is a fundamental right or a constitutionally protected right? I mean, I think I would put it this way: if it's expressly stated, like freedom of speech or something, then we start with a presumption that is constitutionally protected. If it's not specifically stated, then you're free to argue that it is. And, this is the argument with abortion, gay marriage, and, it would be, again, the argument for renunciation of citizenship, right? Is this the type of, the interest that should be recognized as having constitutional status, right? I mean, look, I don't know what the answer to this is. All I'm saying is that regardless of what you think about this, there's very, very clear evidence from the courts and government lawyers that renunciation is not a constitutional right. I mean, where it ends up, I don't know. But I mean, I don't see how that can be good news, right, for people who value the right of expatriation.
And I would say this about Roe versus Wade. It was one of the most destructive cases to the rule of law. And here's why. Because it actually undermined the truth of the founding of the Constitution. Because what you look for, again, what Madison would tell you is look for the express power. Where did the states, whatever the case is, in gay marriage, abortion, whatever the case is, where did the states give this specific power to the federal government? That should be your inquiry. We shouldn't go any further. Does the federal government have that power? So what? Now, this is what Powell did, and I do believe it was Powell. This is what he did. He's like, well, we need to look at the penumbras of the Fourth Amendment. We'll go to the Fourth Amendment penumbras and find where it is. Like, dude, all we need to do is understand we just got to do the actual constitutional, we have to do a constitutional inquiry. Does the federal government have this power? When did the states give this specific power to the federal government? But see, Powell is a big state guy, so we just want that question. He doesn't want that question, does the government have the power? Because to them, the government has all power and we'll just weed out what we think you deserve. So that's what I would say. The problem is like, well, why are we looking at the penumbras of the Fourth Amendment? Why not just look at the structure of the Constitution? Why do we need to go there? Because now you're misleading people, I think, down the road. Next question we got from Heloise. Uncertainty for Americans overseas. What did you get up? Yeah, okay. All right. So what do we? Yeah.
I think I think I'd be interested in your view of this, but I'll shoot something out.
Yeah, I'll tell you mine right now because I have a lot of clients on the fence right now, like doing it, and I'm saying, guys, do it because if you're thinking about it already, you should do it because the reason why you're thinking about it is like, yeah, I don't really think I'm an American anymore. And so the reason why you're not hanging on to it is because like, well, I might come back to the United States at one point and I might want to do this and might want to have this flexibility. Well, this flexibility is costing you everything. So for something that you might not really want to be a part of, you really might not want to be a part of. So where I'm at, I'm telling you guys, you've been thinking about it. It's time. Do it. Do it. Renounce. It's going to be so long before. I mean, who knows what's going to happen here? I would get going on it right away. John, what's your feeling on it?
I think that people need to think about this and distinguish between habitual thinking and common sense. I think that for the vast majority of Americans abroad, U.S. citizenship is the most dangerous thing they have in their lives. And I think that they should get rid of it while they have the chance.
What you said, John, is 100% true. There is nothing as dangerous in your life as your U.S. citizenship if you're overseas. Absolutely. No, that's it. Get rid of it. Get rid of it. You will. I mean, look, I talked to my clients who gave it up a while ago. Any regrets? My only regret is I didn't do it earlier.
That's exactly what they say. But, the second part of the question is LaHood or anything else. I want to make one narrow comment, and this is not a criticism, okay, but it's an accurate comment. The LaHood bill does not end citizenship taxation. It provides a carve-out in certain circumstances for certain people. And until citizenship taxation is completely ended, I think that Americans abroad will always be at risk. But in any case, next.
Yeah, and again, and my criticism on LaHood is his top donor is Ernst & Young. Last 10 years, his top donor has been Ernst & Young, a firm, perhaps the firm that made more money off of FATCA than any other firm. So I'm sorry, I don't trust it. Nope, not going to trust it. So he came out of nowhere. He was not part of the dream team. Why did he come out of nowhere? Why didn't he want to align his vision with ours? Why did he do this on his own? Yeah. All right, we got our last question here. Eric, reminding us, Eric, thank you for this comment, right? The loss of the right to vote while incarcerated is a form of civil death. Utterly medieval. And not the good kind, because some medieval things are pretty good. Some aren't. And actually, I think we're far worse than the medieval times. Far worse.
Well, it's
I think we want to go back to those times. I think we want to go back to the Star Chamber and claim the Star Chamber is a bad thing. But when you compare the U.S. law to the Star Chamber, when you compare it to the Inquisition, it's nothing. We wish we had those days, those beautiful. I would love a draconian tax code. I would love. Oh my God, what an amazing improvement that would be.
Anthony, what occurs to me looking at Eric's comment there. So let's assume that voting were a constitutional right. If it were a constitutional right, then I'm just thinking out loud. Okay, I think the Aforium decision might very well, be extended to not allow people to say that prisoners could not vote. Right. In other words, to retain the right. If they can't strip you of your citizenship, they can't strip you of the incidence of your citizenship. If there were a right to vote. That's how I would argue that. But what's interesting is it's precisely because there is no constitutional right to vote that they get away with this. Right? I mean, it's even worse. It's even worse than I think people imagine, if they imagine it. Right? I mean, they're saying, well, this is the madness of sort of the masses of Americans say, well, yeah, we're going to strip them of their right to vote. They don't realize they don't even have a right to vote. or if they do,
We're
it's,
gonna strip you of the thing you
statutory
don't
right now.
have, right? Yeah. Oh my God. So, what a show today. All right. Well, I want to thank everyone for joining us. I want to thank everyone for joining us today. And if you are thinking, a great time, if you're thinking about renouncing your citizenship, look no further than John Richardson. Those tricky ones, those tricky ones. And also, oh, by the way, and I want to thank that. And I also want to give a plug to Keith too. Keith's channel on Facebook, American Expatriates. Go there. I think we're over 1,100, 11,000. Keith keeps growing. And you always can reach out to Keith too. I can put his email up here somewhere. I have it around here somewhere. I think so. Here it is. Here's Keith's email if you want to reach out to him. I know people are looking for him. So if you want to reach out to Keith. Likewise for me, if you want to support this channel and keep it going, I'm not sure exactly what's going to happen with the U.S. tax code, but my guess is you do want to file your 2024 return. And if so, how about my firm? Go to IRSMedic.com/prep. We can help you out, get any complicated return done. We really, I think that the way that we look at the tax code, we're a little bit different than other U.S. tax firms. We look at it as a bad thing. We don't think it's a good thing. We think it's a bad thing, and we understand the human element of it, obviously. So yeah, give it to us. We have great service, and we will offer audit protection as well. All right. So with that, I think all right, John. So I think we handled another great podcast. But yeah, I'm curious if maybe we want to do one on the right to vote. The right to vote is not a fundamental right. Isn't that crazy?
Well, I don't know what it is, but it's, there's clearly confusion over this. I think people have really got to take a step back and say, you know what, I'm living in an extremely unpredictable, mad kind of world, and I need to take the steps that are necessary to protect myself. I think that the idea of, being able to rely on any kind of common sense, morality, or fairness in governments anywhere around the world is severely misguided. But
yeah, you're entitled to the amount of fairness you can get. There you go.
yeah. Okay. Well, there we go. I mean, there's no end of topics, right, Anthony?
Yeah. All right. Well, we'll see. We'll circle back with Keith. Hopefully, we'll get him on next week. So, with that, Anthony Perrin for John Richardson. Thanks everyone for joining us today.
See ya.